Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer. So I have a great topic for you today. I'm going to talk about one type of waiver when you're applying for removal of conditions on your 2-year permanent residence. So someone asked me about that waiver yesterday, and I want to take some time to explain that waiver process. The divorce is called the I-751 divorce waiver. The I-751 is the application that's filed when you are going from a 2-year permanent resident card to a 10-year. Hi there, Salman. It's nice to see you. So when you go from the 2-year to the 10-year, what you're doing is you are taking those conditions off. So the reason for those conditions is the 2-year green card is like a probationary period for the married couple to show that you continue to have a bona fide marriage during the 2-year period after getting the green card. Then after you've proven that you have a bona fide marriage by either filing jointly with your spouse or applying for a waiver to apply on your own, it's at that point that you can go on to get the 10-year green card. But how do you end up getting the 2-year in the first place? So the 2-year green card is given to anyone who is married for under 2 years at the time that they're given they're approved for the green card. So 2-year green card goes to married couples, to the immigrant spouse in a marriage that's less than 2 years old. If it's over 2 years, then you will get the 10-year green card and you wouldn't have to worry about applying for removal of conditions. But once you apply for the removal of the conditions, that has to be done within 90 days before the card expires. They're also going to want to see updated evidence that your marriage is bona fide. You have to jointly file with your spouse unless you apply for a waiver. If you apply for a waiver to apply on your own and it's approved, you would still get the 10-year. When will you need the waiver? And that's what I'm going to mention here. You will need the waiver if you're divorced. So within the 2 years after getting permanent residence, if you're divorced, then you want to make sure that you apply on your own. Don't ignore it. Don't assume you won't qualify. But what you will have to show now is you'll have to show the final divorce decree, and you'll have to show the evidence that your marriage was real, even though it didn't work out. That you did have every intention, you entered the marriage with the intention of staying in the marriage, but like so many marriages, it just didn't work out. So the important aspect of the waiver is, 1, to show the divorce decree, and 2, to be able to show that you had a bona fide marriage. Now, do you have to apply for the waiver even though you don't? Can you apply for the waiver even though you haven't finalized your divorce yet? Yes, if your divorce is pending, then you can still provide evidence that you have a pending divorce and then request the waiver. They will issue a request for evidence for the final divorce decree and then make a decision after they've received the final divorce decree. But it's always good to let them know, the Immigration Service know, that you're now applying for a waiver. The best thing you can do is get legal representation through your process so you get the right guidance to be able to navigate this process. Because it may not be the easiest and you don't want to make mistakes, especially since the assumption is you will be applying for it on your own without the spouse, and they're going to have questions. Thanks for the love. I appreciate it. So go ahead and put your questions in the comments and I will answer your questions. I have filed I-130 for my wife in 2020 and I got citizenship in January. So your wife is now going to be the spouse of a U.S. citizen. And so it depends on where it is. If it's already approved and it's at the National Visa Center, you'll have to notify them. that your spouse is now the spouse of a U.S. citizen, and they'll upgrade her to the immediate relative of a U.S. citizen. But right now, processing times are similar for spouses of permanent residents and spouses of U.S. citizens. But that would be what the next steps would be. Now, another thing is if you file the I-130 and your wife is currently here in the United States, then adjustment of status may be an option here, but I would have to evaluate all the your situation, all the facts in your situation to ensure that she qualifies. You can call us, schedule a consultation. We'll go through your facts and confirm you qualify, and then represent you through the rest of the process. How do I update on her case, my citizenship status from Green Card? So you'll have to get in touch with them wherever the case is. Good day. I had applied for visitor's visa for my kids, and youngest son have an appointment for this year, but the oldest they give him next year. What can I do to bring up the oldest appointment? So unfortunately, this is just a visitor's visa, and there's no, you could ask for an emergency appointment if it's warranted. You do have to show evidence that there's a need for it. If there's a medical emergency or some issue that justifies them coming earlier and for the appointment to be pushed up. But with a visitor's visa, it's going to be hard to do that. But you can always contact the embassy and ask about their procedures there. I checked NVC hasn't received her case. So if the NVC hasn't received your case, you're going to contact the agency that has her case and then upgrade your status. You'll have to show proof that you're a U.S. citizen, and then they'll upgrade the status. If I marry a U.S. citizen in the Caribbean and I'm from the Caribbean, how do I migrate to the U.S.? So Choka, what you'll have to do, your spouse is going to file a petition on your behalf. That's how it's going to start. Once your spouse files a petition, it gets approved. At that point, once it gets approved, then it's going to be moved to the National Visa Center, where they're going to organize, work back and forth for additional documentation, and then work to schedule the appointment. So the first step is for your U.S. citizen spouse to file a petition. Now, always make sure that you schedule a consultation to get the legal advice you need and representation through your process, because you want to make sure that you are qualified, that there are no issues that you'll need to be concerned about, and that you go through the steps in a way that minimizes mistakes, minimizes delays. Right now I'm finding with long processing times, that's a very painful aspect of the process for those who apply on their own, because they don't know the process, they don't know the laws behind the process, and when mistakes are made, there are a lot of delays that can go months or even years as a result of those mistakes. So make sure that you get legal advice and representation through your process. If you would like to schedule an appointment, go to the link in the profile. It's going to take you to the website, and there are 3 ways to get in touch. You can get in touch through the scheduling coordinator by phone, by online chat, or by online form. All right. So let me remind you that I'm also here on YouTube. So go ahead, put your questions in the comments while I'm here. I am going to be going over to Instagram. I am going to hop on over to Instagram in a minute. So if you want to continue this conversation, you can always join me there. You can follow me there. I'm the Immigration Attorney on Instagram. So join me there, and then you can continue to ask your questions, but I will continue the live there. So I don't see any more questions. I'll be back tomorrow at around 4 p.m. Eastern time to continue to take your questions, and also to come with a topic that I think is of interest to you. But today I explained what the I-751 divorce waiver is all about. If you can't apply jointly with your spouse to go from your 2-year green card to the 10-year green card because of divorce or because you're going through divorce, then this divorce waiver may be for you. You'll have to show the divorce decree, and you'll have to show that you continue to have a bona fide marriage, even though, yes, it didn't work out. Even after you've jointly filed with your spouse, if you find that you are going through divorce even afterwards, because processing times are long. We're looking at about 2 years average time for the process. And so much can happen even after you filed your application jointly with your spouse. If you find yourself in that situation, then go ahead and you can still file for the waiver, but make sure you get representation and guidance through your process to ensure that you don't run into any problems, and that you can properly provide the legal basis for you to be granted the waiver. That's where I come in. I do work on these types of cases, and I can help you through your process. So I hope to see you in a consultation, or I hope to see you in a minute on Instagram at The Immigration Attorney. A last note here is that I represent clients in all 50 states and around the globe. So no matter where you are in the United States, I can help you, I can represent you. So go ahead and schedule that appointment. Have a good one, guys. Bye-bye.